Welcome. Today we're going to discuss an opinion reached by the Trademark Trial and Appeal Board in re Douglas Elliman Realty. My name is Scott Slavick, and I'm the co-chair of Barrick's Intellectual Property Group. I have over 20 years of experience representing high-profile clients in all types of intellectual property matters. If you ever need help devising strategies to provide maximum international trademark protection for your brands, searching and clearing new global brands on a rush timeline, reviewing new marketing programs, or advising on risks with respect to social media marketing, I am happy to help. In this case, Douglas Elliman attempted to register the Next Move is Yours for real estate agency services, real estate brokerage, real estate management, and the leasing of real estate. The mark was initially refused by the examiner because she felt that it failed to function as a service mark under sections 1, 2, 3, and 45 of the Lanham Act. The Trademark Trial and Appeal Board agreed with the examiner and held that the phrase, "the next move is yours," was commonly used in the real estate industry, and thus consumers would not associate it with the source of any real estate services. Here's the real kicker. Because of the board's decision, Douglas Elliman could not overcome this refusal by amending the application to seek registration on the supplemental register or asserting a claim of acquired distinctiveness. In other words, it was a death sentence for the application. The question for the board was whether the relevant public, i.e. purchasers or potential purchasers of the applicant's services, would perceive the next move is yours as identifying the applicant's services and their source of origin. The relevant consuming public consisted of all potential purchasers of real estate agency, brokerage, management, and leasing services. Making matters even worse, although the application was based on intent to use, a failure to function refusal may be issued without considering specimens of use. The board may consider the evidence as to third-party use of the designation in the marketplace. In this case, the examiner argued that the applied for mark was a commonplace message or expression widely used by a variety of sources that merely conveys an ordinary, familiar, well-recognized concept or sentiment. Examples of similar cases were in re Volvo Cars, where the board's holding was that drive safely was not registerable for automobiles and automobile parts because the mark would be perceived merely as an everyday commonplace safety admonition. In re Remington Products, the board's holding was that proudly made in USA was not registerable for electric shavers because the mark would be perceived merely as a common message encouraging the purchase of domestic-made products. The examining attorney argued that precedent showed that expressions that merely convey an informational message are not registerable. Determining whether the expression functions as a service mark depends on how it would be perceived by the relevant public. The more commonly an expression is used, the less likely that the public will use it to identify only one source, and the less likely it will be recognized by purchasers as a service mark. To support the refusal, the examiner attached several websites meant to show that the applied for mark was commonly used in the real estate industry to create a double entendre of a consumer who physically and proverbially moves. Because consumers were accustomed to seeing this expression commonly used in everyday speech by many different sources in the real estate industry, they would not perceive it as a mark identifying the source of applicant services, but rather as only conveying an informational message, argued the examiner. In support of its argument, the applicant submitted third-party registrations for other slogans and taglines. Examples, "Where's the beef?" "Just do it," "Finger licking good," "Eat fresh," as examples of the registrability of slogans and taglines. The applicant argued that "the next move is yours" requires several mental steps to discern the meaning of the phrase and does not immediately and merely provide an informational message or idea. But the numerous third-party uses gave strong support to the examining attorney's position that the phrase is a commonplace message or widely used expression in many different industries that conveys an ordinary, familiar, well-recognized concept or sentiment. Here, the third-party internet evidence in the records demonstrates general use of the next move is yours in advertising to consumers and to businesses in a variety of industries. This evidence shows that the next move is yours would be perceived not as a source identifier, but instead as a widely used phrase, specifically a call to action or directive that the consumer or business contact the entity that is advertising the particular service. The board noted that the next move is yours has a double meaning in the context of real estate services, but it is not a significant double entendre since both meanings are informational. The primary significance of the next move is yours remains a commonly used call to action by advertisers to consumers and businesses, as well as informational slogan used by realtors and moving companies. The board concluded that consumers would not perceive the proposed mark as a source indicator pointing uniquely to applicant. Instead, they would perceive the next move is yours as a commonly used informational slogan by multiple entities. And so the board affirmed the refusal to register. You have to try to avoid these refusals at all costs because they are a death sentence for your application. A survey will not help you. Huge sales and advertising will not help you. Only alternative may be trying to disclaim one or two of the terms, and perhaps that could get you around the refusal. Also question if the applicant had disclaimed move, whether the applicant might have gotten this application past the examiner. Essentially, if you want the USPTO to approve your trademark, make sure the matter you seek to register is more likely to be associated with your brand than it is to be considered merely an everyday use or ornamental display of the designation. If you have any further questions, please feel free to contact me or any of the Barrick lawyers that you typically deal with, and we'll be happy to help you.